and welcome to this Zoom feature between me, Rita Gupta from LGFL, and Jennifer Lee, Counsel from Pump Court Chambers. Welcome, Jennifer.
Hello, thank you very much, Rita, for inviting me.
So if I can just give an overview about why Jennifer and I wanted to do this collaboration, we thought it would be a really good idea to give clients some general information about 3 questions and the answers to 3 questions, essentially. So, shall we now move on to question 2 that I have been regularly asked over the last few weeks, and that's about how will my financial settlement be impacted by coronavirus? You can understand that a lot of people who've had ongoing cases are incredibly anxious by the current economic climate.
Rita, I would highlight 2 major areas that I've seen my financial cases being impacted upon in relation to financial settlements. Whether or not those settlements are about to be sealed, or whether the parties are still in the midst of negotiating. The first major area I've seen is in relation to the issue of maintenance.
Yes.
Which is understandable because so many people now, unfortunately, are facing cuts to income. Many people have been furloughed or are facing redundancy. So we have seen an increasing number of inquiries and possible applications also to apply to vary maintenance orders, either downwards if you're the party paying, or upwards if you are the party receiving. The other way I think maintenance has also been affected is for those parties in the middle of proceedings where they are preparing Form Z financial budgets and so on. In those cases, I expect that your income needs, your budget, your outgoings budget might very well have to be revised because people are making cutbacks and tightening the drawer, tightening the purse. And also, I think from a more strategic perspective, as a lawyer, I'm having to see a lot of cases where my clients are going back to the drawing board and generally just rethinking what they can afford. And that will involve the lowering of expectations in relation to what can be achieved by way of having to pay maintenance or receiving maintenance moving forward. The other area that I think has been very greatly affected is in relation to valuations.
Yes.
And I'm talking about the valuation of properties, businesses, pensions, shares, investments, and so forth. Now, Rita, you and I will know that it's a critical requirement to reaching fair settlements for our clients that we have reliable valuations for assets. And in the current climate, with such volatile stock markets, with house prices having fallen in some cases very dramatically and not selling, that has become a real concern. And in certain cases, is making certain clients thinking twice about whether or not they should delay or suspend their court cases.
Absolutely. I mean, touching on some of the things that you spoke about, I mean, linked to the income point is obviously mortgage borrowing capacities, because I have a case whereby mortgage borrowing capacity was obtained, but they're now facing job instability, a potential income reduction, and they're not comfortable, understandably, to take that existing mortgage on, which does change the landscape of the case and the parties' abilities to rehouse, because let's face it, the majority of our cases are going to be needs cases, whether they are in varying degrees. Agree with the housing market. I mean, the majority of most people's money is in their house, and the ability to rehouse is at the forefront of everybody's mind, particularly if there's young children. So, you know, that people may have to measure their expectation and reduce their housing requirements. It may no longer be available for them to have a 4-bedroom property. It might have to be a 3-bedroom property. I agree with share values. I've had cases where the share values have massively plummeted and we're having to revalue, put more information before the courts. Pensions, that's one where quite considerably they have reduced in values. And particularly, I've had a couple of cases where we've had actuaries' reports, and now those figures have changed, and people are coming back to say, well, that's not fair, we need to recalculate. So what's your view on that element in relation to the pensions and recalculating?
I have to say that in quite a great number of my cases, and I predominantly deal with medium to high net worth, Rita, and those clients, I think, understandably would have more resources to be able to sit through the current pandemic. So there's no real urgency to move things along. The general view has been to delay matters, to suspend the court proceedings, because both parties see the benefit of waiting until the current pandemic, which is, in the grand scheme of things, a short-term issue, one would hope, and then reevaluating, and then once the pandemic is over. So I'm seeing quite a lot of medium to high net worth cases going down that route. Simply because parties realize that there is a great risk in relation to the reliability of valuations for not just the home, but significant businesses and pensions. And just coming back to the point you've made about pension reports, the values of pensions shifting almost on a daily basis. Well, I think that certainly would be ringing alarm bells if you have a pension which is a significant asset. And so therefore, if the whole purpose, and it is the whole purpose of financial remedy proceedings, that a settlement reached is fair, and fairness is really about ensuring that the parties and the children's needs are met, but also that parties have a fair share of the matrimonial assets. I would be very, very reluctant if I were the judge to endorse any settlement where it's obvious that the reliability of valuations are very much up in the air. You know, you can't say a settlement is fair in those circumstances. So I'm afraid that many couples might take the view that there is merit in delaying matters, and ultimately, if a settlement, for example, if the only asset is the family home and the value of that family home has reduced significantly, so that selling it now would effectively make both parties homeless, I can't see how you can proceed.
No, absolutely. But none of us have a crystal ball. We don't know. I mean, if we believe what we hear in the press, there's going to be another recession. It's going to be economic doom and gloom. It's got to be determined on a case-by-case basis, hasn't it? We can't generically say to everybody, adjourn your case and hold off. But at the same time, I think there's a lot of sympathy amongst judges that parties may be extremely hesitant in committing their future at this particular time. And nobody's going to accept a pandemic value, for example, are they?
You're absolutely right. And it's important that we emphasize that this is it's not by any means advised to any particular client on a particular set of facts. It's a reflection of what we have seen. These are really some observations from both of us, having looked at individual cases, but of course every case is different. And by contrast, I think, Rita, if I could also mention that on the one hand, having medium to high net worth cases where parties might be very comfortable in waiting out the pandemic. On the other hand, there are some cases where assets are very modest indeed.
Yes.
And also background circumstances might dictate that the parties really want to move on with their lives. They want matters to be concluded, and we can well understand that. It's a perfectly, they're entitled to take that position, and we have to respect that. Yes. And I would say that actually in those cases where, for example, if a party takes the view that despite the reduction in the value of a pension, that pension, however, is not a very significant asset. And given that both parties want to move forward, there is no reason in principle why a settlement cannot be reached, because it might be that to wait a few more months down the line, would have a knock-on impact, for example, in relation to a person's health or mental health.
Absolutely.
It could have an impact perhaps on a house value reducing even further and not being able to sell.
Yeah.
Because I've certainly come across cases where a client, despite the current situation, have received offers for sale, offers to buy a family home. And a lot of people are understandably very anxious to capitalize on what is a silver lining there, and to push through a settlement so that they can move on. So
absolutely, you can't value on,
there are various circumstances.
you can't put a value on emotional well-being, and particularly if parties have been in protracted proceedings, they may have new partners, for example, they may just want to get on. And I think we also have to think about proportionality of costs in constant adjourning and putting things off, and revaluations. We've got to think about all of that in the context of a case. But certainly I would say there is merit in people quite legitimately saying, I'm not ready to make these decisions now, it's not the right time for me. And I think there would be sympathy with that.
Yeah.
The other thing I was going to touch base with, I think even more so, it's important to ensure that risk is equalised between parties. What are your views about that, Jennifer?
Yes, having said all of that, of course, it's perhaps in my experience as counsel, easier said than done, because in quite a few cases, one party has an unrealistic expectation of what he or she is entitled to. And unfortunately, you will have some cases where one party wishes to have all the copper-bottomed assets relatively foolproof, not susceptible to any great fluctuations in value.
Can you give some examples, Jennifer?
Well, I think a very classic example really is where a party says that, well, I would like to keep the family home, which although has reduced in value somewhat in the current climate, but property investments are still a relatively safe and stable asset to hold, and it's liquid. It's an asset which is relatively easy to sell, compared to, for example, a family business, which the other party is meant to be keeping, which will have very little value, or very or a similar value, but be very difficult to sell, and also be subject to fluctuations in terms of the economy. And so that's a very classic example that we see very often in our cases. And so there's a very great imbalance there between a party having relatively safe liquid assets on the one hand, and the other party keeping the quite risky and very difficult to sell asset on the other.
Absolutely. And I think if there's been one party who's traditionally been the higher earner and may in ordinary circumstances have been willing to take on that risk, I think it's quite legitimate to say, no, I'm not, I don't have future job security, my bonuses may go, I may be taking a pay cut, I may be at risk of redundancy. So in those circumstances, I think we would be advising clients that, definitely the risk, should be equalized between the parties. That would be the fair position under these circumstances, because we have no idea what's going to happen with people's employment.
And a judge would be far more likely to approve a settlement which very evenly or as evenly as possible ensures that the risk is balanced.
Absolutely. So the last thing I wanted to discuss with you is, what about if a client said, well, I've settled last month or just before coronavirus, and now what I've settled on is just not going to meet my needs. It's not what I thought my future would be like. I want to unravel this. So in those circumstances, what would we be speaking to clients about?
Rita, there is a possible solution here in relation to what the lawyers call an application to set aside an order. on the basis of a Barter event. It's called a Barter event because it arises from a case called Barter and Barter many years ago. My main message on this, though, is that Barter applications and applications to set aside generally are very, very difficult to mount. They are exceptionally difficult to succeed upon. And the courts have made this very, very clear. To put it very simply, you are effectively asking the court to set aside an order on the basis that a new event, new circumstances have happened since the order was made, which is, and this is the key phrase, which is unforeseen and unforeseeable, and which invalidates or undermines the entire basis of the order. So you have to meet those requirements. And in addition, you have to ensure that the application is made very promptly after the order is made. And we're talking about weeks, if not necessarily months. And in any event, we have never come across a case where an application is made more than 12 months after the order is made, and which has succeeded. So we're talking about a very, very short time frame. And Rita, bringing this back to your particular question involving coronavirus, the pandemic, if a party were to say that this order is now hugely unfair because the value of the asset I've retained has greatly fallen in value, I'm afraid the current case law is against that party. And I mention in particular a case called Meyerson and Meyerson, which was decided in 2009. And this is a Court of Appeal decision. So it comes from some authority, where the court said that, well, actually, in that case, the husband had retained very valuable shares and investments. But the economic crisis then hit, because it was 2008, 2009. And by the time he brought matters back to court, he was severely in debt. And so his needs were not even met by that stage. And the Court of Appeal said, well, actually, fluctuations in investments, fluctuations on the stock market, is not actually unforeseen or unforeseeable. And so the Court of Appeal declined to set aside the order. And I think that case is going to, have great influence when it comes to any application made in the current circumstances by someone who wants to set aside.
But arguably, I think people are going to argue that a global pandemic that is unprecedented, I think we need to make the point that we've never dealt with any of these circumstances before in our career, is unforeseeable and unforeseen.
One can try, but I highlight, of course, the circumstances in Meyerson, which relates to the financial crash in 2008, which I suppose, playing devil's advocate, one could say was on a scale which was completely unprecedented and caused by all these reputable financial institutions having conducted themselves rather reprehensibly, which no one thought would happen. But, I'm expecting possible challenges to be made. And so I think that's absolutely a very interesting space to very carefully watch.
Absolutely. And I think one of the things we're going to say is the circumstances you were talking about is when parties have had an order, not if they're in the negotiation stage or they've got an FDR pending. Is that right?
Yes. So what we were talking about a moment ago in relation to setting aside on the basis of a Barter event is when a party already has an order in place and you are trying effectively to convince a judge to set it aside on the basis of new events which have occurred.
Absolutely. So if you're in the negotiation process and perhaps are in the early stages of reaching a settlement, that's not what we're saying then. There may be quite legitimate reasons then for everybody to go back to the drawing board. So Jennifer, one of the things I wanted to talk to you about was that I've recently had an order whereby a first appointment has been adjourned indefinitely, and actually what we've been told to do is explore alternative methods of perhaps agreeing directions outside of court or having a private FDR hearing. Now, can you elaborate a little bit more about that for me, please?
Well, Rita, thank you very much for raising this point. Private FDRs are becoming increasingly popular
Yeah.
and indeed very helpful in this current situation, because so many court hearings have had to be adjourned. Your case, for example. And what private FDR is really an FDR which is not taking place within the court system, but being conducted privately between the parties with the assistance of an experienced counsel or former judge or part-time judge who sits as the private FDR judge. So instead of having a judge in a court building,
Yes.
you have a judge who is conducting the FDR, who is not a judge in the sense that he or she is not employed by the judiciary, but is a very experienced lawyer dealing with financial remedy cases. And certainly my chambers and myself included, we deal with private FDRs on a regular basis, both in relation to representing parties and also in relation to acting as the private FDR judge. It's a very convenient and efficient way for parties to be able to resolve or progress their case despite hearings having had to be adjourned.
Absolutely. So it can, one of the advantages is that it removes the delay potentially that could be in proceedings. So the other issue obviously is that it's a private FDR, there are costs associated. And what would be your comment on that if people were saying, well, that's our main concern about the costs?
I don't think cost really should be a concern to clients, because if you think about it, very experienced FDR, private FDR judges would charge, certainly looking at my chambers, we offer very competitive rates, and looking at other chambers as well. I think, you know, a very, very good private FDR judge would charge typically in the region of £3,000 to £4,000, at most about 4.5, 5, if you're looking at the QC. But I think if that cost is to be shared, and weighing that fairly modest cost with on the one hand, and on the other hand, the delay, and this might be very many months of delay, waiting for another court hearing, and also not having the flexibility to actually choose who your FDR judge is, because one thing I should mention on private FDR judges is that, of course, it's a consensual process where both parties can nominate the person who should be their private FDR judge. So both parties will have the confidence that the person chosen is their preferred judge. Whereas an FDR in the court process, the parties have no choice whatsoever in relation to who their judge might be. But bringing the conversation back to the cost on the one hand and the delay on the other, I think sometimes, given how modest the cost is in going to a private FDR, that completely is outweighed by the significant delay which parties will face in having to wait for a court hearing, not being able to choose their FDR judge. And also, I think increasingly, there are costs associated with the delay itself. So, for example, a lot of work might already have been done by the respective legal teams in preparation for a hearing. The court, in my experience, there's a pattern of them adjourning cases at the very last minute. Both parties have done all the preparation and incurred the cost of that. Well, is there any reason why the parties shouldn't then move on to agree a private FDR, because they've already done the preparation for that in any event? And so actually you're saving, you're utilizing the cost that you've already incurred in a productive, cost-effective manner.
Absolutely. And I think that, you know, obviously private FDRs aren't right for everybody. Some parties will not and do not have the means to pay. And perhaps there would be a perception by some people that it doesn't have the same clout as a judge sitting in a courtroom giving that indication or making those comments. So I think it probably has to be looked at in the light of the case and the different parties and how they would perceive that. But parties who it will work for, those who will go into it viewing it as an FDR and with a real positive attempt to try and settle their case.
Yes, and Rita, I don't think that clients need to be concerned at all that a private FDR will not carry the same weight or clout, because they can be rest assured that those who undertake private FDR work are very, very experienced in this field. You know, so I think private FDRs are very much the way forward here.
Absolutely. And I think, you know, judges are under an increasing amount of pressure with lots of matters in their list. On a private FDR, ordinarily, you would be the only matter in the list. So perhaps there's that assurance that all of the documents have been read and absorbed, and, you know, that your judge on the day is literally focusing on your set of circumstances and doesn't have three other behind him in the list.
Absolutely. Parties are very much in control of the process.
Yeah. And I think for anxious or nervous parties, you know, going to court is daunting. To be able to have an FDR process outside of a courtroom would be helpful for many.
And I entirely agree. My experience of private FDRs have been wholly positive. And actually, because both parties are invested in a process,
yes,
they have confidence to start off with in the private FDR judge that they have chosen together.
yes.
The chances of a settlement are so much higher, in my view.
So that's an option available in financial remedy proceedings. So Jennifer, I want to move now to question 3 and our final question, which really the advice that we're going to give is going to cover both children, family injunctions, which is that people are asking, how is my court hearing going to be conducted at this present time?